Yesterday, the U.S. Supreme Court gave us its decision in a case called Tyler versus Hennepin County. The result, I must say, was not surprising. The unanimous decision for the court was written by none other than the Chief Justice, John Roberts. In his opinion, the Chief Justice tells us that a municipality violates the takings clause of the U.S. Constitution if the municipality conducts a real estate tax foreclosure but does not pay off the surplus above the amount of the taxes to the owner of the property. This decision, I think, puts to bed another dispute or split among the circuit courts of appeals. In those cases, the circuit courts, as I said, are divided on whether or not a real estate tax foreclosure can be attacked as a fraudulent transfer. Well, it seems to me that if a real estate tax foreclosure can violate the Constitution, then it's not much of a step at all to say that a real estate tax foreclosure can be a fraudulent transfer. But here's what I think is really interesting about issues raised in yesterday's opinion. You see, back in the 1990s, the Supreme Court handed down a decision called BFP. And in that case, the Supreme Court said that a regularly conducted real estate mortgage foreclosure cannot be attacked as a fraudulent transfer. That decision was eminently reasonable based upon multiple practical considerations, because the Supreme Court knew that every year there are thousands, perhaps tens of thousands, of real estate mortgage foreclosures, and the High Court did not want those thousands of foreclosures to be attacked in a subsequent bankruptcy case. Well, things have changed since the BFP opinion was handed down. These days, the Supreme Court opinions are written by what the justices call themselves to be textualists. That is to say, they look at the text of the statute to decide what the result would be, and they don't consider practical considerations, which were very much underpinning that BFP opinion. So that's why I wonder if the Supreme Court today, if it were faced with BFP, would reach the same result. Because if you look at Section 548 of the Bankruptcy Code, or for that matter, state fraudulent transfer law, there is no hint of practical considerations. Those statutes tell us that a transaction is a fraudulent transfer if you're insolvent and if the transaction does not give fair consideration. And that can often arise in a real estate mortgage foreclosure where the debtor is insolvent, but there is no surplus given back to the owner. That's why I think we have to think hard about whether BFP is still good law. In yesterday's opinion in Tyler, the Supreme Court tells us that people have a constitutional property right in the surplus if there is a foreclosure. So I'm not sure how a court can say there's no fraudulent transfer if constitutionally protected property is taken away from an insolvent debtor and there was not adequate consideration given in return. I am Bill Rochelle, the Editor-at-Large for American Bankruptcy Institute. I shall return same time next week with something interesting in the world of bankruptcy. Until then, be well, stay safe, and a good day.